I'm back with part 4 of delay tactics in Florida Family Court and what you can do about them. In parts 1 through 3, we discussed delay tactics in service, discovery, and mediation. So visit my profile for those videos. Today, we're going to assume you've gotten through mediation, even if it resulted in an impasse, and you have contested issues for the court to decide, which means you need to schedule a hearing. A contested family case concludes with what is called a final hearing, also known as a trial, but there can also be temporary relief hearings along the way before you get to that final hearing. I see big delays played out here with scheduling. To schedule a temporary or final hearing with the court, you have to get on the court's docket or schedule. The judges have very busy schedules, so hearings are often booked months out. Even before you're able to get on the calendar, though, delays can happen. When I, as an attorney, need to schedule a hearing, this is what I do. If there is another attorney on the other side, I contact them to let them know I'm going to be setting a hearing and find out how much time they would like for their side. I usually then double that time so we both have equal time to present in the hearing. Then I email the judge's assistant or JA and copy the other side asking for dates and times for a hearing of that length. The JA then checks the court's calendar and responds with dates and times of availability. Both sides are then supposed to discuss, agree on a date, and then send the agreed date and time to the JA. Once there's a date and time certain, either the moving party will file a notice of hearing or the court will issue an order setting hearing depending on the circumstances and the judge. Delays can happen at any and all points throughout this process. There can be delays in responding to asks from the other side about how much time they need for their presentation at the hearing. They can also delay in responding to the JA's proposed dates and times. And if they wait long enough, the court books up and the proposed dates are no longer available, which means they have to look even further out on the calendar for new dates. If the delaying party waits long enough without responding to a request about how much time they need for the hearing, the requesting party can possibly just email the JA, copy the other side, and ask for dates based on how much time they would like. Usually, in order to bypass the other side on things like that, though, you do have to show that you have made reasonable efforts to get a response. I often see at least 3 attempts to contact the other party considered to be reasonable efforts. The other thing you can do if the other party is refusing to agree to any dates the JA proposed is just ask the court to set a hearing without the other side's agreement. Again, you're going to have to make those multiple attempts to contact the other side, and those attempts usually can't be just back to back on the same day. What I recommend is an email one day, then a phone call with a voicemail the next day, and then a follow-up email saying you left them a voicemail and you're asking for a response by a date certain. Let them know in that email that if you don't hear back from them by that day, you're just going to ask the court to set the hearing without their agreement. Because of all this, it can sometimes take months to get a hearing scheduled, unfortunately. Then, once you get a hearing scheduled and notice, the other side can file motions for continuances. As I've said before, technically a continuance has to be for good cause and not for undue delay. But what I see in practice is that really no questions are asked on that first motion for continuance of a hearing. Basically, everyone gets one freebie, and it's really hard to show that that first motion to continue is for bad faith delays. If they keep moving for continuances after hearings are being scheduled over and over and over again, then eventually you will have more of a basis to fight them. But that first one is going to be granted in my experience. The only exception I'd say is if the continuance is requested at the very last minute, maybe right at the hearing. But even then, if it's the first time, it's probably still going to be granted. If the continuance is granted, then you're back to square one with scheduling all over again. So that process of scheduling and rescheduling can really take up a ton of time. One thing you can do if this is happening in your case is ask for a temporary relief hearing. It's still going to require scheduling, but usually they're shorter hearings, so the court has more availability for them sooner. So that means you're looking at maybe a few weeks to a month out for a 1-hour temporary hearing, as opposed to possibly several months for an all-day trial. In a temporary relief hearing, you can ask for things like a time-sharing schedule or parenting plan, child support, alimony, interim partial equitable distribution, which I'll have to do another video about sometime, exclusive use and possession of the marital home, and other types of relief that you could ask for on a permanent and temporary basis. It's important to keep in mind that these would all be ordered only on a temporary basis, so they're always subject to change at any point up to the final hearing. But it would at least give you a court order that you could follow and enforce while you're waiting for that final hearing if that's something that's needed in your case. It's definitely something to think about and a strategic decision to make. Discovery can also cause delays during the scheduling of hearings. If one party is asking for additional discovery or interrogatories from the other party before going in front of the court. This may be another reason to request a temporary relief hearing because a party does not have a right to hold up temporary relief hearings in a family case for discovery purposes. But discovery does have to be completed before the case goes to final hearing. Those are just some of the common delay tactics I see between mediation and final hearing. Stay tuned for part 5, which should be the last video in this series. It'll be about delay tactics at final judgment and beyond. Thanks for listening, and as always, stay safe out there.